Hello everyone, and I'm K.Bakiyaraj and working as professor at Dr. Asst.Prof. College of Arts and Science. Today we are going to discuss about some few key terms about retrenchment. Retrenchment is termination of employer of the service of workmen of any reasons, whoever otherwise than the punishment inflicted by the way thus indisciplined action is said to be as a retrenchment. The retrenchment does not include some few things about the first thing is voluntary retirement of the workmen is not be comes under as a retrenchment. Term number two, retirement of the workmen or reaching the age of superannuation, that is not be considered retrenchment. Retrenchment number third term is termination of the services of the workmen is not considered, that not include as a retrenchment. Point number four, termination of the workmen on the ground of continued by due to by ill health. And next one is we are going to discuss about the second term about termination. So termination is, what does it mean by the termination? Every employer has decided to exit the workers at any set of reasons of any allegations done during at the time of the employment. So termination is simply mean that end of existing contract between the employer and the employee to be working together is said to be as a termination. The decision to the termination may be taken by the employer or the workman of employee himself. And what's reasonable reason for termination? Point number one, not abiding by the rule of organization or being to be undisciplined. Point number two, any theft or fraud or in any of dishonesty will happen during the workplace. Point number three, willfully making a loss of the employer's goods. And point number four, taking the bribes of reasonable reason. That is a reason for termination for being absent for more than 10 days without any prior intimation to the employer. That is a very important reason that the employer has decided to terminate at any situation. Being an ignorant of the orders given by the workers, and if there is any careless behavior happened by the worker side, and that is one of the reasons for termination. And what are the procedures for the termination? First procedure is valid ground for the termination, that is for misconduct, incapacity, very poor performance, redundancy, retirement, and end of the contract. And procedure number two is about the notice period. Every concern has to be given 30 to 90 days prior to the permission for notice to the period for the concerned workers, and no termination for during the particular leave. And procedure number four, of documentations and record keeping must be there for terminations. And who may represent for the parties for the workmen for the during the termination? One is representation number one is by the trade unions, and number two the workmen representatives, and number three is direct representations. So what's the trade unions? The workmen are often represented by the trade unions or workers associations in disputes and negotiation. These union act has been collective bargaining agents. And second representation is about workmen's representatives. In some industrial dispute forums, representation of the workers are elected or by selected by the employees may represent, and then negotiation or conciliation process. And representation number three parties are that representations. In certain circumstances, the individual or the workman may represent themselves by the labor tribunal through by less common sense. And representation about four is about employees representations. The management representations, the employers may be represented by the senior management, HR personnel, or other designated officers in labor matters such as disputes, negotiations, and conciliations. And representation body number five was employers associations. Employers often have any organizations and associations that represents their collective interest in labor matters. And representation number five is last point is about authorized representations or representatives. The employers may be appointed by the authorities representatives, including legal advisors or the consultancy on behalf of the matters concerning the labor law. And the next representation parties are government officers and conciliation officers. Who is the persons we call as in government officers? The labor law dispute often involve government officers like labor commissioners or inspectors who act as mediators or adjudicators. These officers are neutral in the parties. And the last representation people is about conciliation officers. Who is the person we call as in conciliation officers? The appointment conciliation officer is who be appointed by the government as conciliation officers help to resolving dispute between the workmen and the employers by encouraging them to reach their amicable settlements. With this part today we concluded about some few parties of industrial dispute forums. So thank you all. Thank you so much.